Judge Quinn, in a few minutes, is going to discuss with you some of what's been happening over the past year. I want to spend my allotted time focusing on the future and some challenges and some changes that we're going to see over the next few years. As you know probably better than anyone, the number one challenge we face is the number of self-represented parties continues to grow beyond what any of us could have anticipated. We see them across the board, primarily in family and civil cases, but also in criminal matters and now in the Supreme and appellate courts doing arguments. The fact is the explosion of self-represented parties is no longer a trend. What we have is a national phenomenon that's not going to go away and requires a proactive response by the branch. And just to reinforce for a second that this is a national problem, not a Connecticut problem, I want to focus on, again, just a few of the other states. This is sort of across the board from California to Connecticut. But in New York, 1.8 million litigants appeared in state courts without an attorney last year. 78% of litigants in traffic cases are self-represented. And like us, 90% of housing matters involve at least one self-represented party. Likewise, in Wisconsin, 70% of family cases have a self-represented party. And in Massachusetts, 92% of the defendants are self-represented. So what's the problem with these numbers? The blunt answer is the judicial system is based on a model where lawyers advocate for their clients. A recent survey of judges in New York indicated the following. 63% of judges responded felt that it was difficult to ascertain facts as evidence is not properly presented. 73% indicated unrepresented litigants failed to present necessary evidence. 70% felt there was confusion over the issues. And 84% felt there was a lack of knowledge about the law. And I'm sure that your experience has been exactly the same. I know there are some who question the wisdom or the propriety of the branch's efforts to assist self-represented parties by providing services to them. And I believe, though, that to ignore them is to ignore our primary responsibility as judges, which is to make sure that justice is actually being done. And even if you disagree philosophically, practically, we have to respond because it's proven day in and day out, and you all know this again far better than I, that uninformed self-represented parties can slow down an entire docket, which results in delays and frustrations for everyone, including judges and the bar. We also know that self-represented parties today are not only litigants who can't afford an attorney. In this do-it-yourself world that we currently live in, some of these individuals are highly educated and represent themselves because they simply do not want to spend the money to hire an attorney or feel that they can do a better job. They also have access to technology that we never could have imagined even 10 years ago, which leads me to the second development that has changed the way that we have to do business. Technology has made it easier for self-represented parties to obtain information about the law. The internet has evolved into a vast repository of information that is readily accessible by doing a Google search, and research that used to take days now takes minutes. Even more significant, businesses have also tapped into this do-it-yourself market. We also know that lawyers are struggling to maintain their clientele while at the same time we're confronting an influx of people who in the past would have hired lawyers. Obviously, attorneys are greatly affected by this development, and they need to be part of the solution. Just this past Monday at the CBA's annual dinner, I encouraged the bar to confront this problem and suggested a number of things that they need to be considering if they're to stay relevant as a profession. Bottom line, I told them, our judges need you in the courtroom. The irony of all this is that LegalZoom.com has, according to Bloomberg Businessweek, filed an IPO in the amount of $120 million earlier this month. Frankly, I would much rather see that money going to the legal profession so that people are represented in our courtrooms. Obviously, we also have to be part of the solution. So how do we as a branch respond? The answer lies in three key areas. Number one, we have to continue working towards the 5 goals that our initial strategic plan, namely providing access, addressing changing demographics, accountability, delivery of services, and collaboration, with an emphasis now on determining what changes are actually making a difference in the courtroom. Number two, human capital. And this is important. Our initial strategic plan focused on the people who come to the court and use our services. It's now time for us to look inward and concentrate on the human capital within the branch. Specifically, we want to focus on job satisfaction and career opportunities so that we can retain our most valuable judges and staff which will in turn enhance the branch's performance as a whole. Finally, number 3, and what I'm going to focus on for the rest of my time, is that we must re-engineer our court system. First of all, we need to take a serious second look at how a court case should be processed. In other words, the outcome has to be the same, but we may need to revamp the means by which we get there. Let me stress that the following are ideas we need to think about, not necessarily answers that we have made final decisions about. I don't want anybody out there to have a heart attack on me, okay, in the next few minutes. For starters, we need to consider increasing the use of mediation and/or arbitration. It's less costly for the parties, and we know that many businesses are turning exclusively to private arbitration. Our entire civil system is currently geared towards culminating in a jury trial, which actually occurs only in a very small percentage of cases. So to stay relevant, do we need to make mediation and ADR the main track instead? Should a trial become one of the several options available to litigants, not the assumed culmination of a lawsuit? These are questions we need to give serious thought to now if we're going to stay relevant. Another area that must be examined is how we assign civil cases. As you know, any number of judges may be involved with a single case at any juncture. This is often frustrating for the parties, the attorneys, and the judges, in that it encourages neither consistency nor familiarity. Individual calendaring, whereby a case is assigned to one judge at least up to the Under individual calendaring, the improved consistency could also be especially obvious during the handling of discovery and other motions within a case. There will also be more predictability in the scheduling of hearings, conferences, and trials. In addition, it seems like the number of unnecessary or frivolous motions filed in a case will decrease. Other benefits of individual calendaring are that judges will be able to rule more quickly because you will know the case and settlement negotiations at all stages of the process will be more meaningful and hopefully productive. Our goal would be that the disposition time of cases would be reduced, the frustration of attorneys and parties would be minimized, and the satisfaction of all, judges, attorneys, and litigants, would be greatly improved. This is obviously a significant change, and to make it actually work, I'm currently forming an advisory group composed of judges and staff. The group will be charged with looking at best practices and developing a model that will succeed in Connecticut. One of the things we found, we've been going around the country to see how people are doing it because we're one of the few states left without individual calendaring. And people have very different systems in the states. So beginning in the fall, new cases will be selected and be assigned to one judge in several judicial districts of varying size, with the remaining districts to be phased in over time when we make sure that the process actually works. Now moving to another area, we anticipate that e-filing of family matters will begin by the end of next year. As we all know, this has been a huge success on the civil side. This, coupled with the expanded use of video conferencing and advances in our computer technology, are moving us one step further towards creating the virtual courtroom, where the parties and the judge can be in different locations when necessary and/or appropriate. We are also beginning to take steps that will ultimately lead to electronic filing in criminal cases as well. Finally, legislation passed this session increased certain court fees to provide funds directly for the branch's technology revolving fund. Having a stable, reliable funding source for technology will enable us to plan and implement many technology projects, most notably the expansion of digital audio recording to all of our courtrooms. And this will enable the branch to make audio recordings of proceedings available to the bar and the public on the day of the proceedings, and ultimately reduce the time it takes to produce a transcript and accelerate the appellate process. In conclusion, it's fair to say that the influx of self-represented parties and enhancements in technology have combined to have a huge impact on the way we have to do business as a branch. Of course, we all know that 50 years from now, a whole new generation, thank God, will be dealing with a new set of issues that we could not possibly have anticipated, much like those before us could not have anticipated what we now face. We know this isn't going to be easy. However, I'm confident that with your help and input, per usual, we will do the best we can to assure that justice continues to be served in the state courthouses in Connecticut. So thank you for the opportunity to address you today, and I will turn the podium over to Judge Quinn again. Thank you.
As As you know, each year I begin to talk to you about the budget in the past year and what we have to look forward to. This year has been a very difficult year, and we know that the challenges that we've had to live with this year will continue. So let me just recap what has happened in the last fiscal year. We lost close to $50 million in our budget due to the state's fiscal situation. If you, as a rule of thumb, assume that we're 3% of the state's budget and we have a budget of about $500 million, you can see how drastic that was. It doesn't actually work out quite that way because it was a little higher and so on. But the $50 million was a substantial portion of what we have been accustomed to operating with. And so for the very first time in these 5 years, in each of the 5 years, we've had reductions. But for the very first time, you have felt it in the courtroom in terms of the staff that were available to assist you, the temporary assistant clerks, the monitors, and all of the other people in the clerk's office that until that time had made it appear somewhat seamless. With respect to overall branch hiring, we have not replaced more than 1 in 7 people who left in the past 18 months. So that gives you an idea of the constriction that we have gone through. And despite everything we've done, including removing water coolers from courthouses, really gets down to the nitty-gritty to make everything work, we still have a small projected deficiency, not nearly as large as we thought we would have in January and February, but it did not close out even, which will be the first year in a very long time that that's been the case. So the outcome, despite our best efforts, we were unable to increase work days for the judge trial referees, which we had hoped we could do. And we, as I mentioned, still have small deficiencies in our personal services account and our operating expenses account. And it's particularly difficult to do anything with respect to operating expenses because most of those are fixed lease costs and other expenses we really can't cut. Okay, what's going to happen this coming year? Most of this year's austerity measures will need to continue. The 15% reduction that the JTRs took last year will continue. Now, please, some of you have asked me, is this an additional 15%? No, it's the same. So the work days that you as judge trial referees were given will remain the same. They will not be recalculated. Some other updates. The Committee on Judicial Ethics has redesigned its webpage. It's now quite searchable, so when you have questions about ethics issues that confront you, you'll be able to find them much more easily. We have piloted, I think you who are at the GA know this, a high-volume component of the Judicial Performance Evaluation Program, and that will be moving forward statewide soon. You'll get an announcement about that. It adds some questions about your ability to settle cases so that people who are presiding judges will be evaluated as well because, of course, they're not trying as many cases, if any. It's also the case that the new legislation under the court operations bill, allows judge trial referees to be evaluated. So we will be starting that program for those of you who hear cases.
Good morning, everyone. Prior to our vote on the rules, I'd like to first of all thank Carl Testo, Denise Poncini, and Joseph Del Campo of the Judicial Branch Legal Services Unit for all of their hard work and great assistance to the Rules Committee during the course of the year. I also, yes. I also wish to thank the members of the Rules Committee, Judges Barbara Bellis, Bill Bright, Juliette Crawford, Rich Dyer, Maureen Keegan, Elliot Prescott, Michael Sheldon, and Carl Taylor for all of their hard work during the And finally, I wish to thank all of the judges who either submitted proposals during the course of the year or have commented on the rules prior to this meeting for your participation in the process. Thank you. The revisions to the practice book under consideration today were mailed to you with a memorandum from me on May 31st, 2012. The proposed revisions were the subject of a public hearing conducted by the Rules Committee on May 21st, 2012, and reflect comments received at that hearing. As you can see from the proposals, they involve changes in the rules of professional conduct, educational qualifications for admission to the bar, changes in the grievance procedure and consequences of attorney resignation, reduction in the security fund payment, and certain technical changes based upon statutory revisions and changes, among other things. I wish to call to your attention specifically Section 213, which will be the only section I will ask for an earlier passage date. And that is a revision to Section 213 to make the educational qualifications of candidates for admission to the bar without examination consistent with those for admission by examination. The Bar Examining Committee has asked that the changes to this rule, should you adopt them, become effective on September 1st, 2012, so that the requirements for applications for admission on motion will be in line with those for admission by examination as soon as possible. And I will request that that become effective September 1st. All other amendments I will request become effective on January 1st, 2013. Also, a technical change prior to vote, referring you to Practice Book Section 35A-21. There's a reference in there to Practice Book Section 66-1 of the appellate procedure. That should be changed to 79A-2. I thank Judge DiPatima for pointing that out. And with that, I move the adoption of the amendments to the practice book, which were mailed to you for use at this meeting. Is there a second? Second. Any discussion? All in favor? Aye. Opposed? Thank you. That's passed. I further move, A, that the amendments that's just adopted to Section 2-13 become effective on September 1st, 2012, and that the requirement of Practice Book Section 1-9 that a rule not become effective less than 60 days after its promulgation be waived pursuant to the provisions of that section. B, that the rest of the amendments to the practice book as just adopted become effective on January 1st, 2013. And C, that the reporter of judicial decisions may make editorial changes to amendments, including changes in the section numbers. Is there a second? Second. All in favor? Aye. Opposed? And that's asked if there's any discussion. But hearing none, that passes. Thank you very much.
I think that establishes a record. You've heard the nominations. Can I have a motion to submit the two names to the governor for the Judicial Review Council? That is Elliot Solomon and Marsha Gleason.
So moved. Second.
Bob Shapiro, did you make that motion? All right. We have to keep the record straight. And can I have a second, please?
Second.
I think that establishes a record. Okay. Any discussion with respect to those two names? Hearing nothing further, may I have a vote in favor of their submission? Aye. Thank you. And I take it no one is opposed, and there's no rump candidate that's wishing to move forward. I think that establishes a record. I also would like to ask for a motion and then a vote on the 4 judges who would, 2 of whom would be named as alternates, and those were Peter Brown, Kara Eschuk, Kevin DeBay, and John Mazzaro. May I have a motion? All right. Kara Dooley, thank you. All those in favor? Aye. Any opposed? All right, that work is done. Thank you so much. I think that establishes a record. Okay. Who would like to move for the 4 judges who are presently on for an additional 1-year term? That's Elliot Prescott, Maureen Keegan, Juliet Crawford, and now I will give you the report of the Executive Committee and accept motions for approval of the committee's actions and recommendations. The committee met in May and approved the appointment of all of the individuals and took the actions that are indicated in the various attachments that you have. And I will accept a motion for approval of all final actions taken by the committee as noted in the minutes of that meeting. All right, Matt Frechette moved. Can I have a second? Emmett Cosgrove is our second. Is there any discussion with respect to all of these items? They are listed in the materials that were disseminated to you. Hearing none, would you please signify your approval of this matter by voting aye? Aye. Any opposed? All right, the motion carries. Thank you. The committee at its meeting on May 10th made certain recommendations to the full bench concerning annual appointments of certain branch employees and individuals to serve on various panels and committees. Those recommendations were included in Appendix C of the minutes that were posted on the website. In addition, I would like to recommend the appointment of the Honorable Nina Elgo to the State Bar Examining Committee and to designate Attorney Frank Riccio of Bridgeport as chair of the Statewide Grievance Committee and Attorney Noble Allen of Hartford as vice chair. And I would accept now a motion for approval of the recommendations of the Executive Committee concerning those annual appointments and those individual appointments that I just listed.
So moved.
All right. Doug Levine is the movant, and who can I have as a second? Okay, Peter Brown is the second. Thank you so much. Is there any discussion on any of these items? All right, hearing none, may I have a vote with respect to the approval of these items? Aye. Any opposed? Thank you very much. Now we're to the last item of our agenda, which is any other business that may properly come before us at our annual meeting. All right, I certainly have no more. I see nothing more from the floor, so thank you very much for coming, and we will certainly move to adjourn. You may. Thank you very much, John.
Anything that showed integrity and honesty, I am fully in support of. All right? Yes. But anything that does not, corruption and inappropriate violations of the Connecticut General Statutes or the practice book, I am totally opposed to. So.
Gotcha.
Yes.
Okay. What did you just say? You're going to say hi to Judge Epstein?
I definitely want to, since she wrecked my divorce.
She wrecked your divorce? You
Oh.
want to say hi?
Yes.
Okay.
You know what? You always want to say hi to the people who did that to you.
Okay. All right, Bill, so how did you feel about the whole thing?
It's too fast.
Was it too fast?
Too fast.
Too fast.
Too quick.
What, did you see any hanky-panky going on?
No.
Well, basically, there was no public overview of the rules they passed. How about that? Okay,
I don't understand that
part.
part.
Practice book rules, and there's no public overview.
I don't understand that.
Okay.
I didn't know about the public meeting at the end of May or whenever that was. So I want to look into that. Is that when?
It was done. I walked up here, I put 15 comments, and we just swapped. And this is what I'm talking about. This is illegal. We have First Amendment rights, okay? You're clearly articulating. Well, but I'm just saying is that you want to understand our level of frustration about disrespect? That's disrespect, okay?
Thank you. All those in favor? Aye. Any opposed? All right, that work is done. Thank you so much. All those in favor? Aye. Any opposed? All right, that work is done. Thank you so much. Aye. Any opposed? All right, that work is done. Thank you so much. Okay, you've heard the nominations. Can I have a motion to submit the 2 names to the governor for the Judicial Review Council? That is Elliot Solomon and Marsha Gleason.
Second.
Bob Shapiro, did you make that motion?